warm welcome to all of you here. It's just wonderful to see so many new and old friends gathered together at this conference that I think has meant a lot to many of us in the room. And I also want to send the warmest welcome ever to those of you joining us online. We have about 250 colleagues from across the country joining us, and my co-chairs, the wonderful Sonia Lawrence and Benjamin Berger, and I all were going through the list and just thrilled at the thought of you out there joining us. So welcome, welcome, welcome. Constitutions speak to questions of political authority, distribution, power, rights, and jurisdiction. In a small transcribed lecture entitled On Memory, Aristotle was said to have said, "Without an image, thinking is impossible." What are the images that we might use to think about questions of jurisdiction? John Burroughs, in an article entitled Indian Agency, Forming First Nations Law in Canada, offers some. A meeting can result in one element burning against the crust of another, or one side acting like a prevailing wind that scatters like seeds the norms of the other. How might we think of a meeting without an eclipse? What could be the image? As you can see, I'm stumbling to find one here. But one of the many things I've learned from my excellent colleague, Jeffrey Hewitt, who gave a keynote here at this conference on the subject of land acknowledgements in 2017. A land acknowledgement here at a constitutional law conference should never be so smooth that it slips without friction. So I stop and I stumble here, searching for an image of a meeting without an eclipse. Osgoode Hall Law School recognizes that many Indigenous nations have long-standing relationships with territories upon which its campuses are located and which precede its establishment. Osgoode Hall Law School acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Takaranto has been caretaken by the Anishinaabeg Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory continues to be subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. I wish to end with the words of my colleague, Jeff Hewitt, from his paper that followed his keynote at the conference entitled Land Acknowledgements, Scripting, and Julius Caesar. Hewitt writes, "Reading a land acknowledgement at the commencement of a meeting might be a place to start, but it is the follow-up that counts, the redistribution of lands and resources, the dismantling of systems that uphold colonial power, the end of oppression and exploitation, learning to be uncomfortable, as well as practicing acceptance and not avoidance are some of the necessary actions to begin reconciliation." Thank you.
So good morning, friends. I'm Sonia Lawrence, one of the three co-chairs. I'm just going to do some logistical business here before we get fully settled in for our day. So we're here at Osgoode Professional Development Space in downtown Toronto. So let me welcome you to this space and thank OPD very much for their generosity in letting us use this space and their excellent technical facilities so that we can be both in person and online this year. We're very grateful to OPD for this opportunity to be able to offer a hybrid conference. And we're delighted that so many of you chose to come out and share the day with us. So the washrooms are in that direction. The breakout room is in that direction. This is how we point, right? Breakout room is in that direction. If you're looking for slide decks or draft papers from our speakers, you can find a link and a code in an email that was sent to you probably on April 6th. And if you need to search your inbox, you could search constitutional logistics and that might pop up. So if you're looking for the slide decks, if you're still looking to try to make the internet work, and well, Twitter in particular. I'm not sure how many of us have just given it up and whether, anyway. You can hashtag us with concases with a Z. We're happy to remind all of you that the past papers from 25 previous years of this conference are published in the Supreme Court Law Review and available at the Osgoode Digital Commons open access to everybody. You don't need special codes. And finally, and most importantly, and of course she's not here because she's at the welcome desk. We wanted to not leave it to the end of the day to thank my co-chairs, and I really wanted to take this opportunity to thank Osgoode's Erica Robinson for her skill, patience, general excellence, and dedication to this conference and all the work that she does at Osgoode. You can imagine that our absurd emotional attachment to this conference and our general kind of herd of cats behavior at the end of semester makes this not an easy job. Erica always does it with grace. We're really beyond grateful that she's there to give this endeavor some really solid logistical backbone. So thank you to Erica Robinson, and I hope you guys get a chance to meet her. We have a small gift for her that I'm going to run out and give to her in the middle of her attempts to actually do the logistical work that I'm now thanking her for. But yeah. We wouldn't leave that to the end of the day now. So I am actually going to run out.
Thank you, Sonia. It is my pleasure this morning to welcome our Dean, Mary Condon, to begin the proceedings. Thank you.
Well, good morning, everybody, and welcome to all of you, both in person and, I understand, many of you online, to the 2023 edition of our Constitutional Cases Conference. So a few months ago, I had the opportunity to make opening remarks at another conference together with another dean from York. He went first. He gave a lengthy set of opening remarks and then revealed at the end that he had put the parameters for his remarks into ChatGPT, and it had spat out his opening remarks in about 20 seconds. So I do want to, that's compelled me to feel the need to declare that if these opening remarks are bland and superficial and devoid of content, they are still all my own work, and I did not use ChatGPT to generate them. More seriously, I am delighted to see all of you here today. The annual Constitutional Cases Conference is one of Osgoode's flagship events during the year. It's an opportunity not only to reflect on another year of constitutional adjudication, but also to engage in that reflection with members of a legal community with which Osgoode is proud to be associated. Some of you in this audience may have learned your constitutional law from one of our teachers and scholars over the years, and we're delighted to remain in dialogue with you as you participate in groundbreaking adjudication and detailed on-the-ground analysis of emerging issues in constitutional jurisprudence in Canada. I also want to acknowledge the great efforts of my colleagues, Professors Berger, Lawrence, and White, who are responsible for organizing the conference again this year, and to thank them for doing a wonderful job of diversifying the topics discussed and encouraging detailed discussion of some very cutting-edge issues. And again, like Emily, I also want to express my thanks to Osgoode Professional Development for all of the infrastructure that has been used to put the conference together. I'd like to also express thanks to all the speakers today participating on the panels for the insights you will provide to this audience and the time you've taken to prepare your remarks. It's especially a pleasure to see so many scholars from law schools across Canada represented on the speakers list. I'd also like to especially thank our keynote speakers, our own Professor Emerita Jamie Cameron, who's delivering the opening address, and we're very grateful to Professor Cameron for being willing to continue to share her expertise in constitutional law with this audience and with us at Osgoode. And Professor Linda Colley, whose Laskin lecture promises to be a fascinating account of the history of global constitutionalism. I'm very confident that the keynotes and panels will offer an originality of thought that still cannot be managed by ChatGPT. Thank you very much and enjoy the conference.
So it's my pleasure to introduce to you someone who needs little introduction, I think, at this conference, Jamie Cameron, to provide our year in review. Jamie is originally, I think this is right, from Trail, BC. And if anybody here wants to talk to her about the trail smoke eaters, like among many other things that she can talk very competently about, if you're a fan, definitely seek out Jamie. So Jamie's been Professor Emeritus since her 2020 retirement from Osgoode after a really long and distinguished career. She's almost certainly busier than ever. Among many other commitments, she continues to serve as a member of both the Ontario Review Board and the Nunavut Review Board. Last Friday, I landed at Pearson Airport, which is not always like a great experience, and was really jet lagged and desperate to get home. And I got into a cab and basically closed my eyes. And the cab driver started asking some questions, and I tried to give coherent responses. And then at a certain point, he said, "Oh, you're in law? Do you know Jamie Cameron?" At which point, my eyes popped wide open and I became really happy. So I am, and I was then and am now really delighted to say I do know Jamie Cameron. And I'm soon all of you will at least know her for her incisive and informed commentary on the constitutional work of the Supreme Court. So please join me in welcoming one of the founding chairs of this event, Jamie Cameron.
Thank you very much, and a good morning to everyone, including those who are joining us online today as we welcome another great spring day in Toronto. So I want to begin by congratulating Sonia, Ben, and Emily on the 26th Annual Constitutional Cases Conference. The conference is something I've been very proud of over the years. And I just want to reinforce that this conference has generated a significant body of scholarship that is now all posted on the Osgoode Digital Commons. So that's something I'm especially proud of because we've made a huge contribution to the scholarship with the participation of our colleagues, not only at the school, but in the profession and across the country. So that's just a wonderful accomplishment. And I just want to take a moment to give a shout out to my colleague, my ex-colleague, Patrick Monahan. I mean, really, the conference began with Patrick. And Patrick, as everyone knows, is a monumental constitutional scholar. He was ex-dean of the law school, and he is, of course, now a justice at the Ontario Superior Court. So on to the events of the morning. So the last time I was here at the conference was in 2019, and in this same position on the program. And it was Chief Justice Wagner's, it was the end of his first full year as Chief Justice, 2018. It was the year in review. And this is 2023, and it's the 2022 is the end of his first 5 years as Chief Justice of Canada. So those are nice bookends for me. And it's a great pleasure for me to be here today giving these opening remarks. It's delightful to see so many Osgoode colleagues, so many friends from the profession, to see students here, and to even see some former students who are on the program. And so I'm looking forward to that and catching up with my former student, Alana Roberts, who's on the next panel this morning. So I'm looking forward to the day, looking forward to the lunchtime address by Dame Linda Colley, who I met at dinner last night. And with thanks to my research assistant, Tripit Sandhu, I'm now going to turn to my job, which is to lead you through the details of the 2022 Constitutional Conference, Constitutional Jurisprudence at the court. So it was a fairly stable year at the court, as most of you likely know. The jurisprudence this year has been predominantly focused on the substantive criminal law and criminal procedure, not areas of expertise for me, but I will continue just the same. And oops, I already need help. There, oops, went too far. Okay, so there are guests of honor in their official portraiture as a court, and we can move quickly from there because I'm going to start with just, why was that funny? I'm going to start with just making note of a couple of transitions. So of course, Justice Moldaver retired on September 1. And he's represented in most of the constitutional jurisprudence for 2022. Justice Michelle Obonswin was appointed and sworn in at the court on September 1, 2022. And I've included Justice Jamal as well because 2022 was his first full year on the Supreme Court of Canada. And it's known to everyone in the room that both of these appointments were path-breaking appointments to the court. Justice Obonswin, of course, is the first Indigenous jurist at the Supreme Court of Canada, and Justice Jamal, the first visible minority who was appointed to the court. Justice Jamal, of course, replaced Justice Abella, who retired on July 1, 2022. I apologize for not putting her picture up on the screen, but I can tell you that she has her own documentary at Hot Docs coming up at the end of April. And I have 3 showings in Toronto, so catch up with that if you can. And then finally, Justice Brown is on a leave of absence. We all know that, but I thought is worth noting at the beginning of the day. And also of interest, I took note of the next retirements by age. Of course, there could be retirements for other reasons, but the next retirement by age is Malcolm Rowe in 2028. So that's a few years from now. And the Chief Justice does not reach the age of 75 until 2032. So those are just a few initial notes. So as I mentioned, this is year 5 of Richard Wagner's tenure as Chief Justice of Canada. And I think it's right to describe him as Ambassador in Chief of the Supreme Court. He's worked hard at it. He's introduced some initiatives. He takes them very seriously. And so I just took note of a couple of these. So he introduced the annual Supreme Court of Canada in review in 2018. And so this is the 5th year of his annual reviews. I actually relied on them in preparing my presentation today. And the 2022 edition the theme of it is here for you. So I don't know what you think of that, but the court is here for you, and you'll be pleased to know that they fielded 5,000 calls this year. Okay, also worthy of note are the heraldic emblems that were introduced in 2021. I know that the Chief Justice takes great pride in the coat of arms, the badge, the coat of arms, and the flag, because to the court they represent judicial independence, the Supreme Court's role and traditions. And the other thing that's maybe worth noting as an initiative of the Chief Justice is the hearings that he's initiated across Canada. So the first hearings outside Ottawa were in Winnipeg in 2019. And in this year, there were hearings in Quebec City in the fall term of the court. Okay, so now we're going to move to the year in review. And you know, this talk that we give at the beginning of the conference is typically a bit more quantitative than qualitative. I believe the qualitative matters more to the paper that will be prepared in the next few weeks. But these numbers give all of us a bit of an idea what keeps the judges busy, and might even raise a question, does in my own mind, whether the judges are actually busy enough. So the numbers that we see up on the screen are fairly typical of recent years, and I'm not going to read the numbers out. You can look at them. I'm just going to make a couple of observations or ask a couple of questions. We've talked about this before. You look at the appeals as of right, and the appeals as of right were 19 of 53 in 2022, or 36% of the court's hearing work in 2022. And that's a fairly high percentage, I would say. I don't know what others think. The other thing is that, and we know this too, that in a good percentage of cases, the appeals as of right are just dismissed from the bench, or the ruling is from the bench. So the number there is 32%. I guess my question about the appeals as of right, and it's not a new question, is is this really the best use of the court's time? So I ask that question again. It comes up from time to time. Second thing to note is the leave applications. So I've got an asterisk by these numbers because I didn't understand the court's own numbers on the year in review. I have to go back and look at that again. But it lists 478 leave to appeal applications and only about 30 that were granted. So my math might be wrong. It might not be really 15%, but it's low. It's a low rate of return on leave applications. And I guess the question I'm asking there is, gosh, like, isn't our legal system capable of managing to generate some challenging material for the court, more than 30 cases a year? And I put a little note underneath to Canby Surgeries Corp versus BC. Leave to appeal in the Canby Surgeries case was dismissed a couple of weeks ago. And I was already going to mention it, but the Globe gave it a bit of attention. I think it was 2 days ago in an editorial and an op-ed. And I guess the question is this, is the court hearing enough appeals, and is it hearing the right appeals? I think probably the work's been done before. I just don't remember, but it would be an interesting project to just look at the leave to appeal applications. So let's say in 2022 and draw up a list of cases where the court could have, should have granted leave and see what the docket would look like, whether it would be more than 53 and how many more. Anyway, that's something that I think is an interesting question. So for the constitutional jurisprudence in 2022, I counted up 14 decisions of substance, and this included the decision on standing in BC versus a Canadian Council of Disabilities. The focus very clearly this year is substantive and procedural criminal law. There were no reference questions or other constitutional questions about conventions or other issues, no fundamental freedoms to my disappointment, no language rights, nothing arising per se under Section 35, although questions arising about indigeneity. And there is a division of powers decision that actually is going to be decided as I speak. And so I'm going to deputize Bruce Ryder, if there's time at the end, to check his iPhone and let us know how that one turned out. There is apparently another division of powers decision pending having to do with Indigenous peoples and child welfare laws. But that's the lineup for this year. There were 5 decisions on fundamental justice under Section 7. And they're listed there. I counted up 9 under the legal rights, and then 5 having to do with Section 24(2). There's overlap there because those are also legal rights decisions. 1 major equality decision in R.B. Sharma, and then, of course, the public interest standing decision that I've already mentioned. And I think the number is relatively typical. I haven't gone back to look at how many we can expect from year to year, but it's in the zone of, like 12 to 16 or whatever, but more focused this year than in the past on criminal law issues. So I drew up a win and loss column, and I don't know why that's funny either. It's just fairly straightforward. I like to see what's going on. So that's how I did it. And I'll just turn to the notes at the bottom. And one thing that's interesting to me is that there were 5 unanimous 9-0 decisions in the Wagner court, and they're listed below there. So Brown and Sullivan are kind of a twofer, but there were 5 9-0 unanimous decisions. There are 4 decisions, important decisions decided by 5-4 division. And another point that's of interest to me is that there were 4 decisions that invalidated criminal code provisions. Again, Brown and Sullivan are a unit, but important criminal code provisions were invalidated this year. And that's not something you see every year, at least not in my experience. So back to the court's 2022 year in review. Oops, there's a slide missing. There is a slide missing. Oh, darn. Well, I'll just tell you what's in it. So helpfully, I don't know where it went. Helpfully, the court draws up its own list of landmark and notable decisions. And so, I'm going to actually get my own slide deck out here so I don't make a mistake. And the court identified among the notable decisions it's identified in its year in review, it included R versus Bissonnette, which invalidated 745.51 of the criminal code, which created consecutive life sentences for those convicted of first-degree murder. It also identified R versus Brown, which invalidated section 33.1 of the criminal code, which withdraws the defense of intoxication. And it identified R versus JJ, which upholds criminal code provisions on access to private records in sexual assault cases. And in R versus Lovu, I'm not sure I pronounced that correctly, the court invalidated criminal code provisions for mandatory lifetime registration on the federal sexual offense registry. And then finally, R versus Sharma, that upheld criminal code provisions that place limitations on the availability of conditional sentences. So I don't know where that slide went, but those are the notable decisions. And, you know, in recognition of the panel discussions that will be coming up, fairly shortly, I'm here to do no more than a very short warm up to these decisions. And we'll make a couple of comments about Bissonnette, Brown, Sullivan, and Lovu. I'm going to leave the others, and I'm going to leave notable decision in R versus JJ to the experts, noting that the decision in R versus JJ blossomed to 491 paragraphs. And I will confess that I have not read those 491 paragraphs. So I'll not be saying anything further about JJ. So I do want to say a few things about Bissonnette. I mean, this is clearly a landmark decision. I think the court's right in identifying it as such. And perhaps it was not a surprise to others of you, but I did find it I found it interesting that the court reached its decision by 9-0 majority vote. And I also found it interesting that Chief Justice Wagner wrote the majority opinion, given that, as you'll see in a few minutes, on most issues to do with legal rights, he voted against the offender and the charter claim, but he wrote the majority opinion in R versus Bissonnette. As I said, the court invalidated the consecutive life imprisonment sentences for murder one offenders that was instituted in the Protecting Canadians by Ending Sentence Discounts Act, which was one of the initiatives of the erstwhile Harper government. And so in invalidating this measure, Chief Justice Wagner said on behalf of the court that the provision violated Section 12, which prohibits cruel and unusual punishment because it was intrinsically incompatible with human dignity. And he also said that Parliament is required to leave the door open to rehabilitation. And that was something that was not done with the prospect of consecutive sentences that were actually given to a number of criminal offenders. So the legislative provision is invalid, and the invalidity goes back to the date of its enactment, right? Because it's invalid ab initio. And so it's retroactive to 2011. So it's a consequential decision, right? Because it had consequences not only for Monsieur Bissonnette, but also for a number of other offenders who were subject to the consecutive sentences provision. And according to my internet research, that can involve as many as 18 offenders across Canada, most notably some who've already been through, like Justin Bourque from the Maritimes, Alex Manassian, and in Ontario just recently, Mr. Lamard and Mr. Smeech. So BCNet also has consequences for the families of victims, and the court was not inattentive to their circumstances in writing its decision. But the families of victims essentially responded to the court's ruling with the remark that, well, I guess this means that not every life matters. Not every life matters if a person is no longer required to pay a life sentence in punishment for every life that is taken. So that's BCNet. Just keeping my eye on the time here, doing well. Okay, so next, just say a couple of words about Brown and Sullivan. These are the decisions at the Supreme Court of Canada that dealt with criminal code provision removing the defense of intoxication in cases of self-induced intoxication. So I don't know about the rest of you, but I was a little more surprised about these decisions. I guess it's because I'm of a generation, and I just remember so clearly the day that R versus Davio was decided. I remember all the backlash. I remember why Parliament enacted Section 33.1. And as you know, it removes the defense of intoxication for self-induced intoxication causing bodily harm. And just sort of on a personal note, I taught substantive criminal law for many, many years. And the two cases that were always the most divisive in my fall semester class at Osgoode were R versus Davio and R versus Chalk. And so here's a provision. I didn't look up when it was enacted, but it was probably 1995. Here's a provision that's been in place for almost 30 years. And presto, by a 9-0 vote at the court, it's unconstitutional. And I mean, I find it interesting that the court, I find it interesting in particular when you read the deleterious consequences part of the court's opinion. The court expresses a lot of concern in this decision. Brown is the primary decision, a lot of concern about the risk of wrongful conviction. And I sort of think, well, that's right. Actually, I agree with it, but this is a risk that has been extant for almost 30 years. And it's just sort of interesting that it took such a long time for that to flow up to the court and to be decided by the court. One wonders whether it would have been decided differently by a differently composed Supreme Court at a slightly different point in time. And I'm thinking back to 1999 and the court's decision in R versus Mills, where I think it was Chief Justice, not Chief Justice yet, Justice McLaughlin and Justice Iacobucci wrote the majority reasons allowing Parliament to essentially overrule the common law constitutional decision in R versus O'Connor. And there was discussion about the override and so on in that case. But the criminal code provisions went merrily along their way with the court's blessing. So here we are in Brown and Sullivan with, I would say, fairly muscular decisions by the court. Just a couple of further notes about Brown and Sullivan. First of all, Justice Kassirer, who wrote for the court, was very careful to add that Parliament can treat self-induced intoxication as morally blameworthy. It just couldn't do it the way it did in Section 33.1. So the options that I think they suggested in Davio are still on the table, which are an offense of self-induced intoxication and some sort of criminal negligence offense. But the problem here that there wasn't even a requirement of objective foreseeability of harm. That's point number one. Point number two is that the intoxication, these cases are not the chronic alcohol intoxication cases, but instances of substance-induced psychosis, which is a variable. I'll put it that way. And actually, I should correct the record on one point. I resigned from the ORB in December after being on the board for 10 years. It was a big decision for me. But anyway, to the point related to Brown is that my experience on the ORB was that substance-induced psychosis often came into the forensic justice system through NCR verdict. So we saw plenty of individuals who got NCR verdicts on the basis of substance-induced psychosis, but that was typically for a pattern of drug use that caused substance-induced psychosis rather than what we see in these collection of cases. But one thing I want to do is go back and look at Bouchard-Lebrun, which is a 2011 decision of the court on these issues. Third point, and I'm just noting this in passing, and that is that Sullivan, you should pay attention to Sullivan because it deals with the issue of horizontal stare decisis and judicial comity for courts of coordinate jurisdiction. So that sort of was important, presumably because in this very, very long period that it took for this issue of Section 33.1 to come back to the Supreme Court of Canada, there were different courts of coordinate jurisdiction deciding the constitutionality of Section 33.1 differently. So the court addressed that issue of horizontal stare decisis in the Sullivan decision. Okay, so I'm going back to the court's notable decisions. As I said before, I'm going to take a pass on R versus JJ and just say a few words about Glovu and Sharma, just comment on them together, recognizing again that we have expert panels on these cases coming up later today. I think these are key decisions, right? And in Glovu, the court invalidated criminal code legislation that had a mandatory lifetime registration requirement for sexual offenders for the National Registry, Sexual Offenders Registry. And then, I mean, it's obviously a different issue, but Sharma went the other way when there was a challenge to other criminal code provisions that dealt with the availability of conditional sentences or the unavailability of conditional sentences pursuant to a statutory list. And of course, Sharma is particularly important for its engagement of issues about indigeneity in the criminal justice system. But I just want to take a moment to comment very, very briefly about the court dynamics here. So it is interesting, and both were decided by 5-4 margins in the court. And in Glovu, the majority opinion, I think, conducted a fairly sound Section 7 analysis that found fault with the structure of the National Registry because the registration was being registered on the registry was mandatory and it was lifetime in scope. And both of those requirements were overbroad in relation to individuals, sexual offenders, including Glovu. And so the court invalidated the legislation. But in Sharma, there were also issues about how the provisions on conditional sentences and the offenses for which a conditional sentence was excluded, how they should be read. And the 5-4 majority went the other way. And Sharma is different than Glovu. The provisions are different, obviously, but also Section 15 was in the mix. And I don't know, I'm a little suspicious. I kind of wonder whether the Section 15 element of the claim triggered some members of the court, some of those who are Section 15 skeptics. Maybe I shouldn't say that, but I did. The other thing that's interesting about looking at these two cases together is that Justice Rowe was the swing. So Justice Rowe was with the majority in Glovu, and the decision that invalidated the mandatory lifetime aspect of the National Sex Offender Registry, but he co-wrote the majority opinion in Sharma that dismissed the charter claim under Section 7 and Section 15. I think that's just interesting to note. Meanwhile, Justice Brown, he rejected the charter claim in both instances. So he doesn't like striking these things down. He doesn't like striking legislation down because, as we'll see in a couple of minutes, otherwise on these criminal justice issues, he's a pretty strong defender of the charter claim, but not in these instances where a statutory provision was engaged. So we're through the notable decisions, and I'm going to see if I Yes, okay, I've caught up with the slides. So we'll just look at the justices quickly across the jurisprudence. And this is just a little chart that gives you a very rough idea of what it looked like for particular judges in these constitutional decisions this year, these charter decisions this year. It's more nuanced than the rough numbers would pretend, because there were partial dissents and so on. But you get the idea. Justices Brown, Martin, and Karatsanis were voted in favor of the charter claim most of the time. It's an interesting grouping, I would say. And it also, the middle group are balanced in their approach to these cases, with a little bit more toward the charter claim than against, and Justice Rowe being a little bit in the other direction. But I think it's notable to look at Chief Justice Wagner and Justice Moldaver at the bottom. They were in support of the charter claim 4 times, being Brown, Sullivan, Bissonnette, and what did I forget? I think maybe I included the Council of Disabilities in that, but they were against in every other case, against the charter claim in every other case. So it's worth taking note of that. I also took a look at, this gets a bit more scattered, but I looked at who was writing what. I didn't identify them by decision because it would have been just too messy a slide for me to put together. But what you'll see there is that the workload in this group of 14 decisions is spread fairly evenly across the court. But Justice Brown emerges as a bit of a workhorse. And because he wrote 2 majority opinions and 4 dissenting opinions. His majority opinions were LaFrance and Sharma, co-written with Justice Rowe, and his dissents or partial dissents were in Tim, JJ, Tessier, and Lovu. Also of interest, perhaps, no majority opinions by Justice Cote. Justices Wagner, Moldaver, Kassirer, and Jamal wrote no concurring opinions and no dissenting opinions. And there were actually very few concurring opinions. I think there were just a couple. Justice Kassirer, not a criminal law scholar as far as I know, wrote the very important 9-0 decisions in Brown and Sullivan. I think that's worthy of note. And Justice Jamal wrote 3 majority opinions. He co-wrote the majority opinion in Stairs with Justice Moldaver, and he also wrote in Tim and in Beaver, which I think is the Fresh Start case. I think we're going to hear about that more a little later on. I think that the decision in Janet Murray Hall is probably on your iPhones now, but I just have 2 slides left. Again, a bit of a messy group of numbers, but just a bit of a quantitative review of the Wagner Court over 5 years in comparison with the McLaughlin Court. And you'll see that the number of appeals is down some, and which returns to my question at the beginning of whether the court is busy enough. And it's down significantly, as many of us will know, from earlier years. More appeals were allowed than not in 2018, 2019, and 2020. But the thing that I find interesting is that last column, which shows the degree of unanimity in constitutional decision-making in the McLaughlin and the Wagner courts. And we'll recall that Chief Justice McLaughlin worked very hard to create as much unanimity as possible. And she also seemed to like anonymous decision writing as well, which I really do not like. But anyway, on becoming Chief Justice, and I know I put this in my 2018 year in review, Chief Justice Wagner actually went on the record as saying, I like dissent. I like to see dissent, and he encouraged it. So it's of interest to me, and it's just a small mark. I put it in red. 2022 is the first year in this data set in which the Wagner Court has been unanimous more often than not. And they're up to 55% on that measure. Okay, I'm coming to my final slide, which just has a couple of updates, and perhaps there'd be time for a couple of questions or to find out what the decision was at 9:45 this morning. So Janet Murray Hall is a division of powers case. This is a case that was actually heard in Quebec City. So this is one of the hearings that went on tour outside Ottawa. And so this is a case about cannabis regulation and a dispute between the provincial and federal powers on that issue. I'm also going to point out recent reasons in R versus McColman, which I believe are the first reasons of Justice O'Bonsawin, and she co-wrote in that decision with Chief Justice Wagner. We read in the newspapers, and probably some of you are very familiar with the decision. The Impact Assessment Act reference was heard a short time ago. There was discussion about whether the court should sit with a complement of 8 judges or fall down to an uneven number of 7. I was in agreement with those who think the court should sit as a panel of 8 when one justice is unavailable, but that is not what happened. Justice Brown being on a leave of absence, Justice O'Bonsawin did not sit, and I suspect that practice will continue for the duration of the leave of absence and its resolution. Sorry to report this, but I have to. The Canadian Judicial Council announced that a judicial conduct review panel was being put into motion in the issue of the complaint against Justice Brown. And I think we're all aware that that may take several months to resolve with difficult vulnerability, both for Justice Brown and his family personally and professionally, as well as for the court, depending on what happens. And then just looking forward, the current docket, there's a few cases to watch for as the court rounds out its year. So the mandate letters case is coming up on Monday. This is the issue about whether there's access to the Premier Ford's mandate records and has to do with the cabinet records exemption in the privacy legislation. So that's one to watch for. There's a freedom of association case coming up from Quebec that'll be heard by the court in April. And then there are 2 publication ban cases in May. I didn't see anything else on the horizon, but there's always next year. And so I'm checking the time. I said it would be mostly quantitative. I'm going to have to work on my interpretive comments, but that's our light and breezy introduction to the constitutional jurisprudence of 2022. Thank you very much. What happens now?
Yeah, we have a minute.
Oh, do you want me to keep standing here?
Yeah, sure. We have a minute or 2 from questions from the floor, if anyone.
Isn't Bruce going to tell us what happened?
Oh, yeah, Bruce.
Does anybody know what happened?
Yeah, the appeal was dismissed in a case involving the overlapping cannabis regulation from Quebec from the federal government. So it was a unanimous opinion written by the Chief Justice dismissing the appeal, agreeing with the Quebec Court of Appeal. I know there are a few people in this room who are involved in this appeal. Anyway, for those of you who were hoping to be, if you live in Quebec, to be able to cultivate your own cannabis plants at home, it was a great disappointment. But for those of you who think the court should take a restrained approach to paramountcy, it's perhaps the right result. Suggesting that cannabis regulation is very much like tobacco regulation, that there's room for overlapping federal criminal law and provincial regulation, and the provincial regulation can be more strict than the federal law, which permits cultivation of cannabis plants at home, and the Quebec law does not. So the Quebec law was sustained both in its validity and in its operability, drawing on, some people may be familiar with the Rothmans case from Saskatchewan that dealt with overlapping regulation of tobacco retailing, relied on that case, said this is the same.
So you were not surprised by that result, Bruce?
Well, I don't know. There was obviously room for debate about
Uh-huh.
whether there was frustration of the federal legislative purpose, and there was debate in Parliament about whether they should write into the federal law.
Right.
It's okay for the provinces to take a more restrictive approach here, and the federal government refused to amend the bill as it made its way through Parliament and said, no, we think it's important to allow people to cultivate at home to inhibit the growth of a black market. So,
Uh-huh.
it could have gone the other way. I think the court could have said there is a frustration of federal legislative purpose here, but it's part of a pattern, I think, of the court taking a deferential approach or a restrained approach is a better way of putting it to the doctrine of paramountcy in the name of provincial autonomy.
So it's consistent in your view with the recent division of powers jurisprudence, and maybe we wouldn't go so far as to say that Chief Justice Wagner might be taking a page out of the unanimity book of Chief Justice McLaughlin? Too early to say.
Just to say that experience of this exchange definitely replicates my day-to-day life at Osgoode, which is that a case drops at 9:45, I just go mosey by one of their offices and wait for the discussion to begin. So I think we have just time for maybe one or two questions from the floor. If anyone has any questions for Jamie on how she saw the cases of the year, what might be coming, any of those threads.
As I said, it was a fairly stable year at the court and, quite focused on criminal law issues. So I think the hope is, at least from my point of view, that next year will bring a diversity of decisions that that engage different aspects of the charter and constitutional law.
See, I'm just curious about why you don't like unanimity on the court.
Oh, I don't mind unanimity. I don't like anonymity is what I don't like.
Oh, I see.
I might have misspoken, but I've never been particularly fond of the anonymous Supreme Court decision, especially when it's only a part of the panel. But that's just me. Most other people don't have a problem with that. I felt like saying that I did.
So let me thank Jamie again, and thanks for the update too in real time. I'll invite the next panel up while we think.
Thank you.